Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be continuing with our topic of the Companies Act 2013. We have already completed 2 lectures on the Companies Act and this is our third part, right? It is our third lecture on the Companies Act. So this I have been telling you that Companies Act, it is very vast and it is very important for your examination. So please make sure that you go through each and every question that we are doing here. All these questions, they are really important for your examination, right? Since it is a very vast subject, so you have to be very careful while you prepare for it. You don't have to go through each and every chapter that is mentioned in the act, but you only have to cover the important chapters that could be asked in your examination, right? So we will be dealing with some more questions today. Let's start. Before I begin, I would like to tell you that EduTap has come up with 2 courses for your phase 2 examination. Both these courses are going to be very helpful for your preparation, right? The first one is the test series. The features of the test series includes chapter wise tests. So for each and every chapter that has been mentioned in your syllabus, you get separate test for those, which will be very helpful for your practice. You can practice chapter wise, right? So for example, in IPC, in CRPC, in Companies Act, there are different chapters. These acts, they have been divided into different chapters, right? So on the basis of these chapters, you get different tests for each of those. So through these tests, your preparation will become very easy. You can prepare for a topic and after that you can practice out of these tests. So it is going to be very helpful for you. The second feature includes the full length test with evaluation. So since the descriptive portion has been added by SEBI for the first time, so you have to get your answers checked, right? You need someone who can check your answer and can give you the necessary feedback that is required. So our experts, they will be evaluating your test, they will be giving you necessary feedback and they will be assisting you in how you can improve your answers, right? So it includes full length test with evaluation and you also get one-on-one mentor support. The second course is the live crash course. The live classes, they are already going on and the classes which have already been conducted, you can get the recorded session of those. So if you have not prepared for some topic or if you are confused with relation to any of the topic, you can go and watch that video on that topic. It is going to be very helpful for you. So you get the recorded sessions that has already been conducted, right? You also get short notes. With the help of these short notes, you can prepare your descriptive part answers and these answers, they will be checked, they will be evaluated by our experts. So for the descriptive portion, these short notes, they will come very handy. And all the features of the test series, they are also included in the live crash course, right? And lastly, you also get one-on-one mentor support. So all your queries, all your doubts, they will be cleared by our experts, right? So please make sure that you go through both these courses and you avail our offer which is going on right now. So if you want to avail it, you can refer to the link in the description below. Now let's start with our lecture. Question number 1. What is the term of an independent director? So the answer to this question is 5 consecutive years, that is option B, right? So every listed public company shall have at least 1/3 of the total number of directors as independent directors. So the company, it must have 1/3 of the total number of directors as an independent director. Independent director is a director who is independent in every respect, who does not have any pecuniary benefit in the company, who is not related to the promoters, who is not the KMP, who is not a partner, who is not a CEO. So he is an independent person, an independent director, right? So he is an independent director. Other than the salary that he will get as that independent director, he does not have any other benefit. He does not have any other relation with the company, right? So every listed public company shall have at least 1/3 of the total number of the directors as independent directors, and the central government may prescribe the minimum number of the independent directors in case of any class or class of public companies. An independent director in relation to a company means a director other than the managing director or a whole-time director or a nominee director. So he is not a managing director, he is not a managing director, he is not a whole-time director, and he is not a nominee director, he is an independent director. Every independent director shall, at the first meeting of the board in which it participates as a director, and thereafter at the first meeting of the board in every financial year, or whenever there is any change in the circumstances which may affect his status as an independent director, give a declaration that he meets the criteria of independence as provided under subsection 6. So he has to make that declaration that he is an independent director, that he meets with every condition that has been mentioned in subsection 6. And in case any change it occurs, in that case he has to notify the company, right? So every independent director shall at the first meeting of the board in which he participates as that director, and thereafter at the first meeting of the board in every financial year. So in the first meeting that he attends as that independent director, and in every first meeting of financial year, or whenever there is any change in the circumstances which may affect his status as an independent director, give a declaration that he meets this criteria of independence as provided in subsection 6. Subject to the provisions of section 152, an independent director shall hold office for a term up to 5 consecutive years of a board of company, but shall be eligible for reappointment on passing of a special resolution by the company and disclosure of such appointment in the board report. So he holds his office for 5 years and he is eligible for reappointment. Notwithstanding anything contained in subsection 10, no independent director shall hold office for more than 2 consecutive terms, but such independent director shall be eligible for appointment after the expiration of 3 years of ceasing to become an independent director. So basically, an independent director, he can be appointed for 2 consecutive terms, that is 5 years plus 5 years, he can be appointed for 10 years, right? So he can be appointed for 2 consecutive terms, but after that he can be reappointed for a third term also. But for that 3 years have to be passed, right? So basically what is happening here is he can become a director for the first 5 years, then again for the second 5 years, then 3 years gap is required. After that gap, when these 3 years they expire, in that case for the third term he can be appointed, provided that an independent director shall not, during the said period of 3 years, be appointed in or be associated with the company in any other capacity, either directly or indirectly. But he has to maintain that capacity, he has to maintain that standard of independent director for those 3 years as well, provided that an independent director shall not, during the said period of 3 years, that is the cooling period, be appointed in or be associated with the company in any other capacity, either directly or indirectly. Question number 2. As per section 151 of the Companies Act 2013, small shareholders means a shareholder holding shares of nominal value of not more than dash rupees or such sum as may be prescribed. So the answer to this question is D, that is 20,000. A listed company may have one director elected by the small shareholder, so that the interest of the small shareholders, it can be protected, right? So a listed company may have one director elected by such small shareholders in such manner and with such terms and conditions as may be prescribed. For the purpose of this section, small shareholders means a shareholder holding shares of nominal value of not more than 20,000 rupees or such other sum as may be prescribed. Question number 3. As per section 152(3) of the Companies Act 2013, no person shall be appointed as a director of a company unless he has been allotted. The answer to this question is C, that is DIN number. So, where no provision is made in the articles of the company for the appointment of the first director, the subscriber to the memorandum who are individuals. So, when there is no provision mentioned in the article, in that case the subscribers, the initial subscribers of the memorandum of the company who are individuals, only the individuals, they will be deemed to be the directors, shall be deemed to be the first directors of the company until the directors are duly appointed. Unless and until other directors they are appointed, they are duly appointed, and in case of one person company, an individual being the member shall be deemed to be its first director, and in case of one person company, the only one member, they have only one member, so that member is going to be the director until the director or the directors are duly appointed by the member in accordance with the provisions of this section. So, I hope you know this, that one person company has only one member. That means it has only one shareholder, but it can have more than one directors, right? So, this is why they have written this, until the director or the directors are duly appointed by the members in accordance with the provisions of this section. Save as otherwise expressly provided in this act, every director shall be appointed by the company in general meeting. So how the directors are appointed? They are appointed in the general meeting. So that means they are appointed by the shareholders, by the members. No person shall be appointed as a director of a company unless he has been allotted the director identification number under section 154 or any other number as may be prescribed under section 153. So he must have his identification number, that is called the DIN, director identification number. Every person proposed to be appointed as a director by the company in general meeting or otherwise shall furnish his director identification number or such other number as may be prescribed and declaration that he is not disqualified to become a director under this act. So he has to provide two things. First of all, he has to give the DIN number, and secondly, he has to declare that he is not disqualified under this act to become a director. A person appointed as a director shall not act as a director unless he gives his consent to hold the office as a director, and such consent has been filed with the registrar within 30 days of his appointment in such manner as may be prescribed. So basically the consent of the director in writing has to be given. The director, he has to give it in writing to the registrar that he consents to become the director, right? Provided that in case of an appointment of an independent director in the journal meeting, an explanatory statement for such appointment annexed to the notice of the journal meeting shall include a statement that in the opinion of the board he fulfills the conditions specified in the act for such appointment. So it has to be explained that why independent director has been appointed, and it has to be annexed with the notice of the journal meeting, and it has also to include the statement that in the opinion of the board he fulfills all the conditions that are mentioned in the act. Alright, question number 4. A person can be a director including alternate director in maximum of dash company, subject to that he can be a director in maximum of public company. So the answer to this question is A, that is 20 and 10. Let's read this. No person after the commencement of this act shall hold office as a director including any alternate directorship in more than 20 companies at the same time. So a person can only be director in 20 companies. He cannot be director in more than 20 companies at the same time, provided that the maximum number of public companies in which a person can be appointed as a director shall not exceed 10. And out of these 20 companies, he cannot hold the directorship of more than 10 companies in a public company. So basically, he can be director of 10 public companies only, not more than that. And in total, he can be directors in 20 different companies. Subject to the provisions of subsection 1, the members of the company may by special resolution specify any lesser number of the companies in which a director of the company may act as directors. So if the company wants, they can decrease this number as well. Alright, moving on, question number 5. If a director does not fulfill his duties as per section 166 of the Companies Act 2013, then he can be penalized with minimum of what amount of fine? So the answer to this is C, that is 1 lakh rupees. Duties of the directors. First of all, let's read the penalty only. If a director of the company contravenes the provisions of this section, such director shall be punishable with a fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees. So minimum of 1 lakh and maximum of 5 lakh rupees. Subject to the provisions of this act, a director of a company shall act in accordance with the articles of the company. So the first duty of the director is to act in accordance with the articles of the company. A director of a company shall act in good faith in order to promote the object of the company for the benefit of its members as a whole and in the best interest of the company, its employees, the shareholders, the community, and for the protection of environment. A director of a company shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. A director of a company shall not involve in a situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. So he cannot do anything that conflicts with the company. A director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or his relative, partners, associates, and if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to the gain to the company. So he is prohibited from making any undue advantage, any undue gain, either himself or to any of his representative or any of his partner. And in case he is found guilty, in that case he is going to do what? He is going to pay the same amount. He is going to pay that same amount of the undue advantage that he has received to the company. A director of a company shall not assign his office and any assignment so made shall be void. So basically he cannot assign his office to anyone else, and in case he does that, in that case it is going to be void. Alright, moving on, question number 6. If a company contravenes any of the provisions of sections, that is from 149 to 171 both inclusive, and for which no specific punishment is provided therein, the company in default shall be punishable with fine ranging from, the answer is C, that is 50,000 to 3 lakhs. So if a company is in default in complying with any of the provisions of this chapter and for which no specific penalty or punishment is provided therein, the company and every officer of the company who is in default shall be liable to a penalty of 50,000 rupees, and in case of a continuing failure with further penalty of 500 rupees for each day during which such failure continues, subject to a maximum of 3 lakh rupees in case of a company and 1 lakh rupees in case of officer who is in default. Alright, moving on, question number 7. Company cannot appoint alternate director in place of director who is out of India for a maximum of dash months. The answer is C, that is 3 months. So basically under section 161 there are 3 types of directors mentioned: additional director, alternate director and nominee director. So let's understand all these 3 directors. The first one is the additional director. The articles of the company may confer on its board of directors the power to appoint any person. So basically the power to appoint an additional director, it has been given in the articles. It has to be provided in the articles of the company. The articles of the company may confer on its board of directors the power to appoint any person other than the person who fails to get appointed as a director in a journal meeting. But a person who fails to become a director in a journal meeting, he cannot be appointed as an additional or an alternative director, right? So the articles of the company may confer on its board of directors the power to appoint any person other than the person who fails to get appointed as a director in the journal meeting as an additional director at any time. So basically an additional director, he can be appointed at any time. They do not have to wait for the next journal meeting even, right? So an additional director, he can be appointed at any time. So basically an additional director, he is an individual who has a specialized knowledge, who is an expert in some field which is required to that company, right? So that is why an additional director is appointed, and he is appointed at any time. Do not have to wait for the next journal meeting even. So who shall hold office up to the date of the next annual journal meeting, and he will remain in office till the next annual journal meeting, right? So up to the date of the next annual journal meeting or the last date on which the annual journal meeting should have been held, whichever is earlier. Or if the journal meeting it was not held, then on that case the last date on which the journal meeting should have happened, in that case it will be considered out of both these dates, whichever is earlier. Now the second one is the alternate director. Now who is an alternate director? Let's see. The board of directors of a company may, if so authorized by the articles. So here also you have to be authorized by the articles. The power has to be given from the articles, right? So the board of directors of the company may, if so authorized by the articles or by resolution passed by the company in a journal meeting, or it could be by passing a resolution in a journal meeting, appoint a person not being a person holding any alternate directorship for any other director in the company. So you can appoint an alternate director, but he should not be any person who is already an alternative director for another director, right? Or holding directorship in the same company. And also he could not be any other director of the same company. If he is a director in the same company, in that case he cannot become alternate director for another director. To act as an alternate director for a director during his absence for a period of not less than 3 months from India. So basically when a director, he moves abroad for not less than 3 months, in that case in his place a person can be appointed, that is termed as alternate director. Let's read this section again. The board of directors of the company may, if so authorized by the articles or by resolution passed by the company in general meeting, appoint a person not being a person holding any alternate directorship of any other director in the company or holding directorship in the same company, to act as an alternate director for the director during his absence for a period of not less than 3 months from India, provided that no person shall be appointed as an alternate director for an independent director unless he is qualified to be appointed as an independent director under the provisions of this act. So basically the alternate director of an independent director also has to meet with all the conditions of being an independent director. He should also meet with all those conditions, right? Provided further that an alternate director shall not hold office for a period longer than the permissible to the director in whose place he has been appointed, and shall vacate the office if and when the director in whose place he has been appointed returns to India. So the alternate director, he cannot remain in office more than the original director's term, right? So more than the original director's term in whose place he has been appointed. So he cannot work longer than the original director's term, right? And he will vacate his office as soon as the director, the original director, he returns to India. So provided further that an alternate director shall not hold office for a period longer than the permissible to the director in whose place, that is the original director, in whose place he has been appointed, and shall vacate the office if and when the director in whose place he has been appointed returns to India. Provided also that if the term of the office of the original director is determined before he so returns to India, any provision for the automatic reappointment of retiring directors in default of another appointment shall apply to the original and not to the alternate director. Determined means terminated. So basically, if the original director's term is terminated before he returns to India, in that case, if he is eligible, the original director, if he is eligible for the reappointment, in that case, that reappointment will be considered of the original director and not of the alternate director. This is common sense, right? Subject to the articles of the company. Again, subject to the articles of the company, the board may appoint any person as director nominated by any institution in pursuance of the provisions of any law for the time being in force, or of any agreement, or by the central or the state government by virtue of its shareholding in the government company. So the third clause talks about a nominee director. For example, there is an institution, there is a financial institution who has a shareholding in a company, and that financial institution that wants to represent itself on the board. In that case, he can nominate one person. He can nominate one person. That person is going to be termed as a nominee director. That financial institution that can nominate a person to be its nominee director who will represent its interest in the company, right? So subject to the articles of the company, the board may appoint any person as a director nominated by any institution. It can be by institution of the provisions of any law for the time being in force, or it could be by an agreement, or it could be of the central or the state government by virtue of its shareholding in a government company. If the office of a director appointed by the company in general meeting is vacated before his term of office expires in the normal course, the resulting casual vacancy may, in default of and subject to any regulations in the articles of the company, be filled by the board of directors at a meeting of the board. So it will be filled by the board of directors in the board meeting, which shall be subsequently approved by the members in the immediate next journal meeting. Provided that any person so appointed shall hold office only up to the date up to which the director in whose place he is appointed would have held the office if it had not been vacated. So if a casual vacancy is filled, in that case the new director who is now appointed can only remain in office until the original director's term. For example, we read in the independent director that independent director, he can only be appointed for 5 years. Now for example, he vacates his office after 2 years. Now the new independent director, he can only remain in office for the remaining 3 years of the original director's term, right? So provided that any person so appointed shall hold office only up to the date up to which the director in whose place he is appointed would have held office if he had not been vacated. Question number 9. Which of the following is true? As per section 155 of the Companies Act 2013, no individual shall apply for or obtain another DIN if she already has one DIN. As per section 153 of the Companies Act 2013, every individual intending to be appointed as a director of a company shall make an application for the allotment of DIN to the central government using form DIR 3. As per section 154 of the Companies Act 2013, the central government shall within 3 months from the receipt of the application under section 153 allot a director identification number to an applicant in such manner as may be prescribed. So the answer to this question is C, that is only first and the second statement is correct, but in the third one it should be 1 month and not 3 months, right? Let's read it. allotment of director identification number, the central government shall within 1 month. So, the central government will allot this and it will be within 1 month from the receipt of the application under section 153, allot a director identification number to an applicant in such manner as may be prescribed. Question number 10. Which of the following is true? Resolution by circulation is passed when the details of the resolution to be passed are drafted and sent to the registered address of directors and their approval is taken. As per section 176 of the Companies Act 2013, the actions or the decisions taken by the director when he was in office would not become invalid just because it was subsequently noticed that his appointment was invalid by the reasons any default or disqualification. So, the answer to this is D, that is both of these statements, they are correct. So, resolution by circulation is passed when the details of the resolution to be passed are drafted and sent to the registered address of directors and their approval is taken, and as per section 176, the actions or any decision that is taken by a director when he was in office would not be invalidated just because his appointment was found to be invalid. So, as per section 176, the actions or the decisions taken by the director when he was in office would not become invalid just because it was subsequently noticed that his appointment was invalid by the reasons of defect or disqualification. Question number 11. The overall managerial remuneration payable by a public company to all its directors, including MD, WTD, the managing director, whole-time director, shall not exceed -% of the net profits of the financial year. The answer is B, that is 11, right? So, the total managerial remuneration payable by a public company to all its directors, including managing director and whole-time director and its manager in respect of any financial year shall not exceed 11% of the net profits before salary deduction of the company for the financial year. Question number 12. What is the maximum remuneration payable to directors who are neither managing directors nor whole-time directors in case of a company has no MD or WTD? In that case, the answer is B, that is 3% of the net profits, right? So, the maximum remuneration payable to the directors who are neither managing directors or whole-time directors in case the company has no MD or WTD, then it shall be 3% of the net profits, and if there is an MD or WTD, in that case it is 1%, right? Question number 13. As per section 205 of the Companies Act 2013, which of the following are the functions of a company secretary? So, the answer to this is D, that is all of the above. The functions of the company secretary shall include to report the board about the compliance with the provisions of this act, the rules made thereunder and other laws applicable to the company, to ensure that the company complies with the applicable secretarial standards, to discharge such other duties as may be prescribed. Alright, next question. A dormant company is a company. So, the answer to this question is option D, that is all of the above. A company is formed and registered under the Companies Act for a future project or to hold an asset or intellectual property. Company which has no significant accounting transaction or an inactive company. So, let's read this. This is section 455, dormant company. So, where a company is formed and registered under this act for a future project or to hold an asset or intellectual property. So, basically there are three ways in which a company can be considered as a dormant company. The first one is if it is created for a future project, or it is created to hold assets, or it is created to hold intellectual property, or if it is an inactive company, or the last one could be that it has no significant transaction, it has not made any significant accounting transaction, right? So, where a company is formed and registered under the act for a future project. For example, a company is formed to get a government tender, but that tender has to open 1 year later. But the company, it has been formed now only. In that case, it has been made for what? It has been made for a future project. In that case, it will be termed as a dormant company. So, a future project or to hold the assets or intellectual property, or has no significant accounting transaction, such a company or an inactive company may make an application to the registrar in such manner as may be prescribed for obtaining the status of a dormant company. Now, let's understand that significant accounting transactions are what and what is an inactive company. For the purpose of this section, Inactive company means a company which has not been carrying on any business or operation or has not made any significant accounting transaction during the last 2 financial years. So if that company has not carried on its business for the last 2 financial years or has not filed the financial statements and annual reports during the last 2 financial years, in that case it is what? It is an inactive company, it is a dormant company. And what is a significant accounting transaction? So significant accounting transaction means any transactions other than. So these are the mandatory little transactions which are mentioned here. So if any transaction other than this is made, in that case it is not a dormant company. But if only these transactions, only these payments have been made, in that case it is a dormant company, right? So significant accounting transaction means any transaction other than payment of fees by a company to the registrar, payments made by it to fulfill the requirements of this act or any other law, allotment of shares to fulfill the requirements of this act, and payments of maintenance of its office and records. So now I hope you are clear with what is a dormant company. This question has been asked by the SEBI in the previous examination, so please make sure that you know this. Alright, now question for achievers. As per section 175 of the Companies Act 2013, if dash or more of the total number of the directors of the company think that any resolution under circulation must be decided at a meeting, the chairperson shall put the resolution to be decided at a meeting of the board. So this is 2/3, 3/4, 1/3 or half. So you have to comment the right answer below. Alright, so that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.